Well, they could certainly use the evidence that we developed in this case, but that's a terrible tragedy, almost a ticking time bomb waiting to happen. There are 7 million of these vehicles still on the road, and parents don't know about this danger. Chrysler hasn't warned anybody. They haven't fixed the seats, and just as their expert admitted, children are going to continue to be brain damaged and killed when these seats collapse in the wrecks that we know are going to happen.
And even if Chrysler didn't want to fix the problem by warning parents and saying, if you want to put a child in one of our minivans, put them behind a seat that is unoccupied, because an unoccupied seat won't collapse. That could help parents make decisions about their children's safety. Or put the children in the third row in the middle where they would not be in the way of a collapsing front seat. But they even refuse to give that kind of information to parents so they can decide what kind of risk they want to expose their children to.
I'm amazed that the government didn't make them strengthen or recall every Dodge Caravan or similar vehicle made under a different name and had that seat strengthened. I'm amazed.
There's a lot of misconceptions out there. The public thinks that NHTSA, the government, actually will prevent these kind of product design defect issues, and they don't. NHTSA has never recalled a product. The National Highway Traffic Safety Administration has never recalled a product for a design defect. All the recalls have been voluntary recalls with the manufacturers. The truth is, the automakers own NHTSA. There's a revolving door between the automakers and the leadership at NHTSA, and the automakers have resisted increasing seat back strength for almost 50 years. The minimum level of seat back strength that's required by the federal government motor vehicle safety standards is the same as it was in the 1960s. Now, during that time, we've gone to the moon and back. We've had the computer revolution, and the seat back strength the minimum seat back strength is the same as it was set in the mid-60s. It's frankly absurd, and this continues to happen because the automakers continue to get away with it, and NHTSA lets them get away with it.
Let me ask you, when we're talking about strengthening the seat back, what actually happens to strengthen the seat back? What would they put in there extra to strengthen it?
Well, it's
what's in there now, and what would they add?
Well, in the seat that was in the minivan in this wreck had what's called a single recliner. So basically it was one hinge on one side of the seat.
On only one side? On
one side. So a very easy, safer fix to that is to do what they call a dual recliner design, which is to put
down the bottom.
Right. Now, another thing that you can do is you can do what's called a belt integrated seat, and those are much stronger. They're the seats.
The one over the chest?
Exactly. It's the seats where the seat belt is actually mounted in the seat. And that design by its very nature is very strong because it has to provide the anchor for the seat belt. There are a lot of easy fixes. In fact, one of our experts has done some testing where he's just mounted a seat belt behind the seat just kind of as a brace, and that doesn't collapse rearward in the way that these weak seats do.
In today's world, with Chrysler going bankrupt, out of business, if a person has a problem now with a Dodge Caravan, do they have a claim?
Well, under pressure from the government, Chrysler has agreed to defend and pay product liability claims that happen after Chrysler emerged from bankruptcy, which I believe was sometime in June. June of 2009. So basically, if this happens, as it will inevitably happen to other families, they'll get hit from behind, their seats will collapse, and either they in the seat, the adult in the seat, or a child behind it gets injured. As long as that crash happens after Chrysler emerged from bankruptcy in June of 2009, they can bring a case against Chrysler, and Chrysler will defend and pay the damages in that case.
But there are people who had filed suits against Chrysler whose suits had not finished going through the court system, and their claims were wiped out. So there are people that were injured by these seats that were affected by the bankruptcy.
So these are people that filed before the bankruptcy. Bankruptcy happens, their claim goes away. They cannot refile.
Well, their claim gets dealt with in the bankruptcy court, and there are limitations on what they can recover, and it's on what they can recover, and it's usually some cents on the dollar.
It seems very unfair.
It's extremely unfair.
Now, there was a leadership team, a minivan, Chrysler called this, right? Chrysler minivan safety leadership team that actually investigated in 1992 the seat, the effectiveness of the seat. And they appointed a gentleman by the name of Paul Sheridan, I think his name was, right, to chair this committee. What did they find out?
Basically, the minivan safety leadership team was charged with looking at the minivan and identifying all aspects of it that needed to be improved from a safety point of view.
Yeah.
And they made Paul Sheridan the chairman. They picked him as their chairman. He was part of the minivan executive group. And they began to investigate the performance of the seat and discovered that the seat was collapsing in crashes, injuring and killing people in the seat and children behind it. Mm-hmm. And this committee determined that the minivan seat was not adequate to protect customers. And very telling was the fact of Chrysler's response to that. They actually put their minutes together of that committee meeting and distributed those minutes around the company to some of the high executives in the company. And the response from the company was not, oh, thank you for telling us about this safety problem. Let's fix the seats and protect our consumers who rely on us to put their kids in these seats. The response from the corporation was to order Sheridan to retrieve and destroy, that is, go around and collect all the minutes of the committee meeting that were critical of the seats.
Yeah.
They then disbanded the minivan safety leadership team, and they fired Paul Sheridan. And the jury heard all that evidence in this case.
Yeah, and we're going to go to the trial testimony, videotape trial testimony, correct?
Correct.
Of him talking about that, which I find outrageous. Let's do that right now.
By 1993, we on the safety leadership team were aware of the fact that people were being injured or killed in Chrysler vehicles, minivans in particular, where the front seat backs were collapsing as a result of a rear-end collision.
You have a copy of the meeting minutes for the March 16, 1993 meeting of the safety leadership team?
No.
Did you have a copy?
Yes.
What happened to all the copies?
Well, they were in my office. I distributed them, and after distributing them, I was asked to retrieve and destroy them. He said to me that he had received a telephone call from Mr. Francois Castang.
That's the head engineer?
The head of engineering. And that Mr. Castang, to use the exact word, was livid with the meeting minutes and the fact that we were playing the 60 Minutes video. And Mr. Castang sent out a directive through Mr. Zarowitz to me that we round up the meeting minutes and destroy them.
Wow, that's amazing. They hire a guy to investigate what the problem is, they find out what the problem is, then they fire him, you know.
And I think the whole amazing thing about it is that that testimony was unrebutted at trial. Chrysler did not bring a single witness to say anything different than what Paul Sheridan did.
Yeah.
And on cross-examination, basically they had nothing to discredit what Paul Sheridan said about the merits of his testimony.
Yeah. We have with us today the mother of Joshua, Rachel. She's going to be joining with us in a minute. So let's bring her on right now. I have the great pleasure of introducing Joshua's mom, Rachel Arnold. Welcome to the show.
Thank you.
Thank you for coming here today. You flew all the way from Tennessee, right?
Yes.
Tell us, if you can go back to that day, this tragic day, tell us what happened that day.
We were hit. We were in a car accident on that day. We were pulling out of a driveway, and once we pulled out of the driveway, there was a car that came around, or a truck rather, that came and hit us from the rear.
And it was just all so quick, wasn't it?
Yes.
You were sitting right next to your son, weren't you?
Yes.
In the second seat?
Yes, in the middle row.
What was your immediate reaction? What did you do?
Once everything was done, I immediately looked over and saw that my son's forehead was completely smashed in.
Really? And it was from the force of the head of the person sitting in the front passenger seat, the seat that collapsed?
Yes.
Were you aware that the seats in the Dodge Caravan were so unsafe?
No, we were not.
I think in your trial testimony you were asked, had you known that, you would not even bought this car.
Correct.
You bought it not too long before then, didn't
Right.
you?
It was my parents' vehicle that they
parents?
had bought. Yeah, and they had owned a Caravan years ago and
Yeah.
got rid of it because of the safety issues, but then
Really?
they were told that safety was not an issue anymore, that it was a safe vehicle at that point.
Well, again, I am very sorry for your loss. And money can never compensate anybody for a tragedy like this. And I certainly appreciate you coming on the show.
Thank you.
And one thing I wanted to say about Rachel and her family is that this has never been for them about money. It's been to get the word out that parents need to know about this problem. They need to know that this can be a danger to their children. They need to be aware of this so they can make the decisions that need to be made about a child's safety with the complete knowledge of what's going on. And they've always been very much focused on letting Chrysler know about what happened to their son and hoping that this would cause them to make a change.
Yeah, and that's why we're doing this show, because as of right now, Chrysler has never recalled those Dodge Caravans and other minivans that are made under different names but with the same seat, have they?
Right.
There's other tragedies out there waiting to happen, and thank you for spreading the word again. Well, you got this $105.5 million verdict, tremendous verdict. But the audience needs to know that the work didn't end just with that verdict, did it?
Right, that was 2004, and beginning in 2004, Chrysler took us on an appellate odyssey that spanned the next 5 years. They first asked the trial judge to remit the verdict, and the trial judge remitted the punitive damages, that is, reduced the punitive damages from $98 million down to $20 million, because he thought that the $20 million was a more appropriate ratio to the $7.5 million in compensatory damages that had been awarded. Then, unsatisfied with that, Chrysler appealed to the Tennessee Court of Appeals, and the Tennessee Court of Appeals accepted Chrysler's arguments that the punitive damages were excessive and shouldn't have been awarded, and vacated the punitive damages. We believe that that was manifestly incorrect, because the evidence of punitive damages to support punitive damages in this case was absolutely overwhelming. And so we then petitioned to the Tennessee Supreme Court for a discretionary application for appeal to ask the Tennessee Supreme Court to state what the standard was going to be for awarding punitive damages in Tennessee.
Yes.
And the Tennessee Supreme Court looked at the overwhelming evidence that we put on of Chrysler's knowing misconduct and wanton and reckless disregard for the safety of these parents and these families and these children, and determined that this clearly stated a case for punitive damages. They reinstated the punitive damages award and ultimately affirmed a judgment with interest that came at the end of the process to about $23 million. Chrysler still wasn't satisfied. Chrysler appealed or filed a petition for certiorari to the U.S. Supreme Court, asking the U.S. Supreme Court to take the case and either reduce or eliminate the punitive damages. And we handled both the Supreme Court appellate practice and the practice through the Tennessee courts ourselves, which is kind of unusual. A lot of trial lawyers don't do their own appellate work, but we do. We're both appellate lawyers and trial lawyers, and in fact, the best appellate lawyers are those that also are familiar with the trial record. And so we defended the case through the U.S. Supreme Court, and in May of 2009, the U.S. Supreme Court denied certiorari, and the case came to a conclusion and the judgment was final.
Well, thank God for lawyers like your firm, and I'm very pleased and gratified that we were able to spend some time with us today. Thank you very much, Lee, and thank you very much, George.
Thank you.
Thanks for watching. To get more information about our guest and the cases, please visit www.insiderexclusive.tv. Thank you.